Is it possible to get a J-1 waiver approved in 2025 with U.S. Department of State funding? In this video, that's exactly what we're going to be talking about. This case had 2 RFEs with the prior attorney, and we're going to talk about how we were able to turn it around and get it approved despite the fact that it had a request for evidence. So let's get started. First of all, in order to qualify for a hardship waiver, you need a qualifying relative. You need a U.S. citizen or lawful permanent resident spouse or a U.S. citizen or lawful permanent resident child. Here, the applicant qualified based off of having a U.S. citizen child. Now, we were retained in this case based off of the fact that he initially hired an attorney. Unfortunately, the case received a request for evidence. He decided to turn to our firm to respond to the request for evidence. And in this case, he had a serious risk of denial. The way we were able to address the request for evidence was based off the fact that the client shares custody of his American-born son and plays a central role in every aspect of his life, from daily school activities to his medical insurance. Since the time the case was filed, the hardships only increased. He couldn't take his son to India, nor could he leave himself without abandoning his custody rights. Financially, emotionally, and physically, we argued that the father was indispensable. We immediately had to get to work on the case because, as you may or may not know, usually for the J-1 exceptional hardship waiver cases, you only get 90 days to respond. So despite the fact that we didn't do the initial filing, we collaborated with our client to collect, organize the necessary evidence to create a compelling case. What we also like to do, if there's new documentation available, and this is what we did, we presented new documentation concerning every aspect of the hardship. We also presented extensive country condition evidence illustrating systematic discrimination against Muslims in India, which would have directly impacted his ability to support his son if forced to return. We were able to make it clear that losing his father, even temporarily, would cause significant harm, whose well-being, education, and stability depended on his father's continued presence in the United States. Our legal argument was backed by both facts and precedent, and our evidence was thorough, clear, and well-structured. Now, thanks to this effort, we're so grateful that USCIS approved the waiver, and he was able to now stay with his son in the United States and continue to be reunified instead of split apart. I invite you to take a look at some of our other success stories so you can get an idea of what other kind of cases are successful, and also our persecution waiver videos if a J-1 exceptional hardship waiver is not an option for you. Make sure you subscribe to continue to get these updates, and please like this video if you like it, because it does help the Google algorithm if you like this video, so we can continue to do more videos like this. Bye.